This is, as I mentioned, the Charles Hamilton Houston Institute for Race and Justice's event, Conviction Review in the Age of COVID-19. We are delighted to have joining us today David Lewis, who is the Chief of the Integrity Review Bureau at the Suffolk County District Attorney's Office, and Harold Adams, who is a longtime community organizer, formerly incarcerated jailhouse lawyer, former paralegal at Prisoners Legal Services. And I will give fuller bios of both of them in just one moment. Just some logistics up front. There is both a Q&A feature and just the regular chat feature if people have questions as we're going. The structure of the event, I'm going to open with just some framing questions and then fuller bios of our panelists, and then they'll each have about 5 to 7 minutes to give you some background on their work and how they think about this topic. And then we'll go through some moderated questions and then open the floor for Q&A from our audience. But if you have any questions as we go, feel free to drop them in the chat. So to begin, as you all saw in the description of the event, some of our kind of framing questions about conviction review, sentencing review, have to do with bigger structural questions about decades of public policy based on racism and fear, and how we switch to a model that focuses on mercy and healing, and in particular, what role prosecuting offices can or maybe can't take in, and how they are already taking action, and what are the internal perceived limitations within prosecuting offices to be able to respond to conviction and sentencing integrity issues, and also what are the limits identified by outside organizers in how this process is currently working, how it could be working, and other levers to push in trying to get people out of prison who are serving decades of time. So to begin, I'd like to give you a fuller introduction of our panelists. As I mentioned, David Lewis is an assistant district attorney and chief of the Integrity Review Bureau at the Suffolk County DA's office here in Boston. Prior to becoming a prosecutor, Mr. Lewis was in private practice for over 23 years, where his practice specialized in civil and criminal appeals in state and federal court. He has co-chaired and presented at numerous seminars and continuing legal education programs, and he is the author of many articles on appellate advocacy, and he's a graduate of Hamilton College and the University of Denver College of Law.
Great.
Then we...
Oh, thank you. Thank you.
Right?
That sounds good.
Okay, great. And then further joining us is Harold Adams. Harold provided me with a fabulous social biography that I'm going to read to you. That's written in the first person, but I'm going to switch it to being third person about him. So Harold was born in 1947 in Harlem into a fractured childhood as a family member of third generation ex-slaves. At age 24, he was sentenced to life in prison. In prison, he graduated from Boston University summa cum laude with top honors, and then morphed into a self-taught legal scholar, published writer, band organizer. He wrote briefs and memoranda resulting in the release of 7 people from prison. In 1987, when he was in New York City's infamous Rikers Island jail, he helped win compassionate release for a prisoner, a precedent which then won the release of 53 incarcerated people who were dying from AIDS. His fellow Rikers Island incarcerated people called him Ironsides because police brutality had put him in a wheelchair, and he won a $10,000 settlement in prison. His later legal work set precedents before the Massachusetts Appeals Court, U.S. District Court, and the Board of Immigration Appeals, and he did this all while serving 31 years of a life sentence and then 21 years to date on lifetime parole, including working over 15 years as a paralegal, 11 years from a downtown law firm, and then 4 years at Prisoners Legal Services of Massachusetts. He helped organize migrant and seasonal farm workers in New York on Eastern Long Island's infamous potato graders, and founded the Boston Committee of Friends and Relatives of Prisoners, where with other volunteers, he organized free prison visit transportation for families to every prison in Massachusetts, as well as prisons in Rhode Island and Pennsylvania. He's done work to stop evictions and home foreclosures and utility shutoffs, and he believes he's the only parolee ever in Massachusetts who was given permission to travel to a conference in Italy as a self-taught apprentice mathematician with NATO's Advanced Studies Institute. Another first for Harold and for the Commonwealth, perhaps, he was at a clerk magistrate hearing, which is a prior to criminal complaint issuing hearing in Quincy District Court. He was allowed, while on parole, to successfully argue on behalf of a law firm client, resulting in non-issuance of a criminal complaint. He has been published in many publications: the South African Beacon, Mandate, a pamphlet series, the Trotter Review, and Verdict Magazine. and has been a keynote speaker at schools all around the country. He is blessed with 4 children, 8 grandchildren, 5 great-grandchildren, and is also a survivor himself. 1 year before he began serving 31 years in prison, he was shot in the head and blinded in 1 eye. He survived multiple cancer-related surgeries, and as he says, "I'm here to stay because my heart and spirit are with the evolutionary struggle for a more just and loving world for all." So that's Harold Adams. We are thrilled to have these 2 people with us to talk about all aspects of this issue. And I'd like us to begin with David, if you'll take us to start, just an overview of what your work is, how you see your work, how it has been affected by COVID-19.
Sure, thank you. So as Katie said, I'm the chief of the Integrity Review Bureau at the Suffolk County DA's office for DA Rachel Rollins. The Integrity Review Bureau has 4 basic areas that it concerns. There's conviction integrity, which is sort of the standard, which I'm sure we'll talk about more as we go forward. There's sentencing integrity, which is, in essence, unlawful sentences, or not unlawful, actually, a lawful sentence where, in retrospect, it appears that justice wasn't done for some particular reason. The usual description that we give of those circumstances are where, say, for example, in a sort of a joint venture situation where someone younger, usually peripherally involved, a driver, lookout, that sort of thing, usually younger, ends up with a more severe sentence than the principals in the crime. It may be totally lawful that that's the way it worked out, but that, to most people, when you look at those, and obviously it depends on facts of a particular case, but in general, most people would see that general scenario as being unjust. And so it's trying to find those situations, and then under the current sort of statutory framework and sort of system framework in Massachusetts, again, we're going to talk a lot about this as we go forward, trying to figure a way out to find a remedy. The third area of concern is the lead database, law enforcement automatic disclosure. It's what's often referred to lawyers as a Brady-Giglio list. It's sort of more than that. The lead is a little sort of a Brady-Giglio plus, sort of, is one way to describe it. That is sort of in process of sort of fleshing out to where we want it to be and where we're comfortable with that being. And then the fourth area is case integrity, which is the short description I usually give to people is taking the lessons you're learning in conviction and sentencing integrity of where the system is malfunctioning, right? We're imperfect individuals. Anything we create is an imperfect system, so it's going to make errors, right? But trying to learn from those areas and bring them forward to currently active cases, so that those mistakes can be avoided. So instead of freeing someone with the conviction integrity unit after 20 plus years in prison or more, we can hopefully catch those cases much sooner. And those are the 4 areas. They're, as we will talk more in this hour, they are not progressing at the same rate. There's reasons for that, mostly involving me, but also involving sort of more practical reasons, and then some other just systemic reasons. But that's what I do, and I'm happy to talk about it. I'm happy to have me here.
Thanks for that overview. And yes, we're going to get into the details of all of those questions about prioritization and what's possible and what could be possible, and how outside organizers can help. So Harold, if you could just give us a little overview for your perspective on, what does conviction and sentencing integrity mean, and how should, what role should prosecutors play, and what role is the community playing in trying to get people out of prison who are spending decades of time that is not actually producing safety for anyone?
Right. Well, first of all, I'd like to apologize at the outset. There may be some technical difficulties with my audio and so on. So I want to apologize for that from the beginning. Where I would begin is by the fact that we have to define what the term justice and what does that mean. Can everyone hear me?
Yes, we can hear you, Harold. Keep going.
Okay, right. Okay, so what does justice mean? Now, I give examples. If we start with a slave and a slave master, well, obviously, justice doesn't mean the same thing to the slave master as it means to the slave. So that begs the question of who has the right to define what justice means. Now, I'm sure that everybody of conscience would agree with me that underclass exploitation, oppression, and repression based on social and racial classification are, in fact, forms of systemic injustice. However, the criminal legal system, and I don't use the term criminal justice system, the criminal legal system is rampant with those forms of injustice, and which makes it obvious that they don't define justice in the same way that our community does, and they don't view justice in that same way. They have a very limited definition of what justice means. And I would applaud David Lewis, Rachel Rollins, because for the work that they're doing and their position on this matter. I had a friend of mine who actually worked on her campaign, and he's an ex-prisoner. He told me he was doing that. And I said, "Are you crazy?" And he said, No, I'm telling you, she's different. And I see that. I see that. So this is the work I'm doing. I work on research cases. I do a lot of organizing work. I do a lot of educational work with people to try to bring together all the disparate parts of a movement that can facilitate the kind of work that Rachel Rollins and David Lewis are trying to do, because I do understand that the system is also stacked against them. And I think that the community really has to be front and center in supporting those efforts, but our voice has to be heard in terms of we're the ones suffering from the lack of justice, and we need to define the scope of what that means.
I mean, one thing, I'll sort of building on that, one thing, just it's a little step back, but sort of builds on that, is that one of the things about conviction integrity units in particular that's important for people to understand is that at the sort of 30,000 foot level, like conviction integrity units, you can look at any ones across the country. They'll all pretty much look the same, right? But as you get down to ground level, like what statutes are involved, what are the local politics, like all this other stuff, they're all custom jobs. So to build on what Harold was talking about, like that's why it's so important for sort of people to stay involved. That's why I like make an effort to like talk to people. I call Katy, like I call these people, because I want to hear what's going on. Like if lots of people are telling me there's a problem, then there's probably a problem, right? So that's one of the reasons you do that. And I do that anyway, but I also do it. I mean, the DA's office, in my view, it's a public law office, right? We represent the citizens of Suffolk County. They have absolutely every right to call me up and talk to me, or tell me about a case that's concerning to them that they believe was wrongfully handled, or that an outcome was unjust. And I'll listen to them. And I think I got lots of examples that I'm not so quick with mail. If you write me a letter, I'm not so quick to get back to you, but I do get them, I do read them, and you will get an answer from me. But no, Harold's absolutely right. I mean, you gotta keep sort of that ear open to what people are saying to identify the areas, or to help identify the areas where your focus needs to be.
So let's move and kind of more surgically attack that, because I think, and for purposes of full disclosure for our audience and candid conversations, yes, David and I have sometimes agreed on issues, and sometimes we vehemently disagree about cases that I think have constitutional issues that are worth exploring. And I know that this is true for a lot of community members who are joining us on this call as well. And so one of my questions, and this has been particularly urgent during COVID-19, is how has the Integrity Review Bureau helped secure releases for some particularly vulnerable elders, and also what are the constraints in supporting releases broadly, and what kind of and some of this, I'm going to combine this with another question I sent to our panelists in advance, but some of this may be in part structural issues within the DA's office. And so one question that I think is particularly pertinent is, every appeal that goes through the Suffolk County DA's office could have a conviction integrity lens on it. theoretically, right? Whether there were constitutional problems involved in that. But instead, what seems to be happening structurally is that the office is taking a limited pool of cases, and there are prioritization decisions made about trying to help in particular people who have already served decades in prison, which there's of course a certain logic to. So if you could talk us through some of those political dynamics with as much candor as we can reach in a public setting like this, and the kind of bigger constraints that are impeding your work, and also what you see as potentially levers for change or for broadening the way that the office works.
There's a lot there. So I'd expect nothing less. It's okay. So, on one hand, so we can talk about individual cases, right, that have been in the news, that have been pressed, where we have sort of addressed this, like the Arnie Kings, Tommy Rosas, the, James Watsons, sort of situations like that. But on the other hand, I think it's important to, I think it's a bit of a trap for when conviction integrity units, when you start focusing on individual cases, like where they use that as the metric, like, hey, we exonerated 8 people this year. Like, that's great, but I don't personally believe that is the way I should judge my success, or anyone else should judge it. I think it's important, and it's important to know that, and it's important to like spread that word. But that, to me, isn't the judge of how well we're doing. And that said, I haven't quite figured out exactly what is the metric for whether we're doing well or not. I'm still trying to figure that out, and I've been at the job 14 months now. I'm still sort of undecided about that. The one thing I'll say, as far as, the impacts of COVID is, I think the problems that COVID is showing or exposing, right? I think they've been there the whole time. And I think COVID is merely this thing that's sort of making them really obvious, right? And it's bringing them to sharper relief. Like, I think people that work in this area and have for a long time know, like, something simple, like, okay, a prison isn't like a moon base. Like, it's in a community. People come and go like all the time, delivering food, linen, like there's stuff going in and out of the prison like all the time, right? It's not hermetically sealed. It's not a bubble, right? And we all knew that, but now because of COVID, basically everyone else knows that now too, right? Because people come and go and they've learned this, right? And I think that, again, I mean, we can get into it now. I mean, how the system is set up, right? And how you can see how with particularly life without parole, clemency, the procedural rules that are in place to address those, 25B2 or 30B, right? You can see how, in theory, the system is self-correcting, right? In theory, that should more or less work, but it completely doesn't. Like, it does not work. I didn't realize this when I was in private practice. I sort of was filing my new trial motions, or I would do my work, and I never really thought about the whole thing as a larger ecosystem of how this works, right? And I can see it now because that's sort of what I do now. That's all I look at, is how the system works together. And if you can see how the system is set up to, like, well, okay, if we're going to say life without parole, then you got to have these outlets for it. So if there's a legal mistake or there's an injustice, you've got the defendant can bring the thing, or there's this clemency option. Well, as Katy knows, we've had this discussion. There hasn't been clemency really in like 30 years. Like, there might be one soon, there might be more soon, I don't know. But, at the rate, I think I figured out, at the rate they were granted in the 1970s, it was like 18 a year, right? And if they basically stopped like in the 80s. And if you do the calculations, and I sort of did them on the back of an envelope, and I went to law school, not business school, so you always got to take my numbers with a grain of salt. But you're making, like, if an average inmate is, like $50,000 a year, say, just as make the numbers sort of easy, 18 people, and there's no commutation or clemency for them, and they're still in the system, and you start doing these calculations, it's like $900,000 a year, every year for a different group of people, right? You do this math, you end up with not just tens of millions of dollars, it's like hundreds of millions of dollars, right? And people don't realize they've made this choice. Like, we've all made this choice that that's what's going to happen and that we're okay with that. And it's not okay. Like, I think if you talk to most people, they would say that's not okay. We set this system up for there to be an outlet, like for people that have rehabilitated or whatever, and we want them in the community again because it's safe and everything else. But that system doesn't work, right? So I end up seeing, and the appeals units across the Commonwealth end up seeing pleadings that are essentially clemency petitions, but they're dressed up with legal theories because that's their only outlet. And that's, so, I mean, I think that was sort of rambling a little bit, but you can see like I can see in theory how the system was set up to be self-correcting, but it's not. And then the conversation to me has to be like, okay, how do we fix this? Because it seems everyone I talk to, at least maybe I'm living in a bubble, but it seems like they want to correct this and they want it to work the way it is set up to be intended to work. The question is, how do we get it to do that?
So Harold, what do you think about that? And I just want to say two quick framing things before I give you a chance to respond. One is that I think we can all try to make an effort to use people-centered language as much as possible. So I would encourage us to avoid the use of the word inmate, because I know there are a lot of people who have been in prison who find that word offensive. And one other thing I wanted to note is that you know, there are clearly carceral politics that are involved in those calculations, right, David? And one of the things we used in framing the introduction of this event is the statistic that was reaffirmed by the Sentencing Project yesterday, that there are now more people serving life without parole in Massachusetts than there were in the entire prison population in 1970. So you're not talking only about this dramatic fall off in clemency, which is in part tied to the specific racist history of individual cases and of a man who was released from prison and then was implicated in the shooting of a law enforcement officer. And so that there's a specific punitive culture that grew out of individual events in Massachusetts that have marred then this opportunity for relief valve for dozens, if not hundreds of people. But it's important to note that our prison population has dramatically shifted in favor of more incarceration and indefinite incarceration, as also the valves for relief have closed. So things have been grossly exaggerated, even beyond just comparing to 1970 as a baseline in terms of clemencies. So Harold, what do you think about those kinds of issues, and whether clemency is the right route, or whether there are other levers to push, and how these things kind of work in tandem to get people out?
Okay, I'm going to respond to each one. I think that what David said is on point. In terms of metrics and measuring success, cases overturned, certainly that's one metric, but I think an equally important metric is the degree to which people like Rachel Rollins and David Lewis and prosecutors who are approaching conforming to the true role of what a prosecutor should be, which is somebody who is seeking justice for the people, the degree to which prosecutors work in tandem with the community on the issues that have been collectively prioritized as the issues that should be addressed. And clemency certainly is one of those issues. Now, as far as COVID goes, I would say that COVID is the great teacher. And as David pointed out, it just magnifies the inequities that were already there. But what it does is it establishes the interrelationship among all of us, that these inequities eventually are going to affect and impact negatively the whole society, whether it be COVID or whether it be the inequities in the criminal legal system itself. Now, there is also David mentioned this $100 million figure. I read a document was put out by the Prison Policy Institute, and they quoted, and I trust them, they do great research. They quoted $18.2 billion as the national annual expenditure on corrections on criminal justice system. okay, I did some calculations with that, and if that money was in the bank and the multiplier effect was applied to it, that would represent $1.82 trillion, right? I'm sorry, $18.2 trillion. That is 14% of the gross domestic product of the United States, and it's 14% of all the deposits in all the banks under the Federal Deposit Insurance Corporation. So the point is that without that money that is expended in the criminal justice system, the U.S. economy might collapse. If you couldn't take an $18.2 trillion hit on the economy without it collapsing, and that speaks to some of the rationale why the law and justice are like distant cousins who are not on speaking terms. When you begin to look at some of these inequities, and as far as clemency goes, you know, like I can pull out a couple of perfect cases. Okay, it's a guy, Joe Mesery. He just died from COVID-19, right? Over 40 years in prison. He was eligible for parole in 1995. He kept being denied simply because he said he was innocent. He said that his conviction didn't have integrity. Okay, now he could have easily said he did it, and it probably would have gotten parole. So he probably, you know, we need to look at that. But we have a system where a person who is factually innocent and maintains that position, exercises their First Amendment right and their Fifth Amendment right, and maintains that position, they cannot get clemency in the Commonwealth. Tina Williams, she was out. She wanted her sentence terminated, 25 years on parole. All kind of awards, accolades. She died in hospice waiting for a non-forthcoming response from the parole board. So the clemency in Massachusetts is broken. And I think it's broken in the country. And that's an issue that the community with progressive-minded people who are prosecutors need to address in earnest. Because David, he made a great point. Those motions are essentially clemency positions that have no other tracking other than to appear in the form of a post-conviction release motion. And one last thing I want to say: the system itself is steeped in class and race profiling. In the 60s, the United States Parole and Probation Commission said this. They said that, you know, they didn't have enough resources to go through everybody's social bio, so they would create a profile and they would classify people as fitting or not fitting that profile. And the underlying assumptions behind that profile was that most crimes are committed by poor people and most violent crimes are committed by, quote, Negroes, end quote. And that is the rationale that's reflected in the demographics of the people in prison, the people on death row. That's what's motoring that whole process. And so that has to be addressed. So David spoke of hundreds of millions. We're talking tens of trillions of dollars, and that goes into somebody's pocket as profit out of the criminal legal system.
That's right, Harold, and you're absolutely right to bring us to the kinds of questions of systemic forces in terms of policy choices, and also systemic racism and white supremacy being an undergirding force behind the way that we structured criminal punishment in this country. And I think, you know, we hear the DA talk about those issues, right? DA Rollins is not shy about discussing concerns about racial disparities in rhetoric, but I think there are still questions for me as a lawyer doing particularly appellate work in Massachusetts around continuing kind of protection of ongoing racism that we see in policing patterns today, but also what kinds of redress are required for long-standing issues of policing and prosecution that has resulted in not only the disparate incarceration and punishment of Black and Brown people, but also the disparate wrongful convictions. And I think one question that I pose that I would love to hear you both speak to is, what role does SCDAO have in doing kind of a systemic analysis of the forces that lead to wrongful convictions in Boston? And in particular, this is against a backdrop of a number of cases over the last 10 years from the 80s and 90s in particular, but also some more recent cases of exonerees that are almost exclusively Black and Brown men. David, I don't know if you want to speak to that first, whether there's a systemic role that whether it's your unit or some other piece of the office should be doing in terms of investigating those broader forces of policing and prosecution.
I think it's, oh no, it's me. It's no other bird, it's me. I think this all kind of goes to, the evolution of a conviction integrity unit and sort of the other things on my plate of sort of other areas of responsibility, right? And how that evolves over time as we sort of process cases, as we get a better process. You talked earlier about, prioritizing. It's a huge issue. Like we've got limited manpower, we've got limited time. It's like, how do we make sure we're addressing the most important cases, the most cases in need of redress, right? And that was why just originally I was like, okay, look, if someone's life without parole, and if someone was even second degree and up for parole, but they've been denied a bunch of times, I would just assume they were life without, right? They got priority, right? Then if someone, I had letters from people that were, maybe the sentence was 10 years or something, and they're up for parole after 6 or 7 or something like that. It's like, look, I can't, in my mind, in fairness, I can't justify doing one over the other. I got to go life without parole and try to help them, right? And I wish I could help them all. I wish we could do it all at once, but we can't. And I think in the evolution of it, as we're going, like as opposed to last year, right? Now we've got an inmate application that we send out for their lawyers or a pro se inmate, and fill it out so that we get some information that we need so we can start making better decisions more quickly and sort of manage who's asking us and what they're asking us, so we can get to the answer more quickly. Is it a DNA case? Is it identification? Is it police misconduct? Like what is it? Like what bucket does it fill in? And then we can start getting more specific answers to our question, right? And try to move it along. I think the evolution of almost any conviction integrity unit or anyone doing this work, I think it ultimately becomes systemic. Like part of it almost has to. Like, and again, this goes back to my original comments about every unit like mine is sort of, it looks similar up here, but when you get down to ground level, it's different because it all depends on the DA. Like it totally depends on the DA, like how much you're allowed to do. There are plenty of units across this country, and Katy can probably rattle them off. I could probably identify a bunch of them too, where there is technically a conviction integrity unit, but they don't really do anything. They get they exonerate 1 or 2 people a year, they get a big press bump, and that's it. That's all they do, right? There are probably half a dozen to maybe it's up closer to a dozen now units in the country that are like being much more aggressive and much more assertive about finding these cases and getting results. The kind of stuff you were talking about, like systemic stuff, and this sort of goes to this other issue, is sort of case audits, where you've got a particular individual involved or a particular practice involved, and then how do you pull that string? Like, how do you do that, right? And how do you figure out, is it all the cases that are involved? Is it some of them? If it's some of them, why is it some and not another, right? You got to have a reasoned decision about how you're doing this and then how you do that. And a lot of that all becomes capacity and like ability to do it. And it usually involves getting defense partners. I mean, I talked to MACDL, ACLUM, I talked to CPCS. It's like, because I talked to, NEEP, I talked to Lisa Kavanaugh at CPCS Innocence Project. it's like those types of cases are so large, like almost the only way we can do them is if we do them with defense help. Like the Annie Dukin cases that are currently in front of the single justice right now, the list 3 cases, like we did those with the ACLU and CPCS. Like they were partners in that, in putting that together, making sure the list is right. And then I have to put a pleading together to resubmit. But that's the kind of thing, like it becomes like much broader. When you start talking about those systemic things, it becomes much broader, like the system of all the stakeholders, right? And this is a topic for a whole nother webcam, but it's like, as you know, like the data, right? Data sharing is terrible in the Commonwealth. It's terrible a lot of places too. We're not alone, but it's not good here. And it could be so much better. And that's something that could make a big difference in figuring stuff out sort of like this, but I'll stop.
Yes, so Harold, same question to you. And I think, I hear you, David. There are these structural issues about data sharing that I know frustrates me in my work as well, in not being able to get accessible data. And I also hear you saying that, of course, you have a limited staff and limited resources, but I want to push back a little, and maybe Harold, you can help us think this through about what it means when you say that the DA's office can't do something, because I think it's still a question of resource prioritization within the office, right? And if, there are choices that are made about whether to appeal granted motions to suppress in trial court and spend appellate resources doing that work, especially when they involve racism in policing, which are some of the ongoing cases that are happening. And that's a choice the office makes, as opposed to that it's something that is just functionally impossible and the office can't do it. So I just want to highlight that dynamic. And again, I think these are complex questions about what role all stakeholders together have in trying to address what are documented patterns of racism and wrongful convictions, and also in just generally harsh sentencing, right? And the racial disparities report that Harvard's criminal justice policy program released highlights that with the best available data showing that these are empirically proven, as well as something that communities have long known, that Black and brown people are serving buckets of time in prison and longer sentences than their white contemporaries. So Harold, I would love to hear from you on these kinds of systemic questions about what's needed to change.
Right. Well, I think the first thing that we have to deal with is criteria with respect to the integrity question of a conviction. What criteria are we using to say that this conviction lacks credibility? And I think if we constrain or limit ourselves to the technical niceties of the law, we're going to end up in the same place that we're currently at, or maybe even in a worse place. So that brings me back to my initial statement about the definition of justice, i.e., what constitutes justice, right? And which would have to be first and foremost in all of our minds, including the minds of any progressive-minded prosecutors who are concerned about this and who are trying to work with the community. Now, we definitely need to assemble more and more forces, and the prosecutor's office, in terms of working with other organizations, other entities, working with the community itself, right, beginning to mobilize more and more forces. One of the things that in the organization that I found at the Committee of Friends of Relatives of Prisoners, one of the things that we did, we had running a legal advice benefit where you had volunteers who were doing a lot of lead work. And I see this also in Families for Justice's Healing, participatory defense. You have people who are lessening the burden of prosecutors, of attorneys, by doing a lot of the work, a lot of the leg work, a lot of the tedious time-consuming work that would be extremely expensive and burdensome on a lawyer's office or a prosecutor's office to do. And but we can't constrain ourselves to just focusing on the technicalities of the law, because that in fact is a part of the problem, whereas the law is not defined in such a way that it's designed to address the systemic inequities that affect the people who disproportionately appear in the criminal legal system and who live under those conditions on a day-to-day basis in the community. So we have to look at the wider picture in our concept of justice and to factor that into our calculus of, wow, does this conviction have integrity? Now, one great example was the Arnie King case, where the issue of the racial issues around the jury selection process. So that that was a look at the social reality of that was in place at the time, and the fact that this man spent damn near half a century in prison. And you look at Donald Trump, for example. Okay, his actions have caused a relationship with the deaths of 3 police officers, another civilian, 140 injured, insurrection, domestic terrorism. He flies off in Marine One. Perfect analogy. Gee, I'm up in the air, in the clouds. I'm above the law. Then you got some kid who's been in prison for 40 years for some crime that happened, 40 years ago, that he may or may not be innocent of or guilty of, and you compare that to a guy like Donald Trump. And so, these are the kinds of considerations that we would have to take, and being people of conscience, right, who are trying to serve the ends and interests of justice from many different positions and different locations. So I think that and then we need to establish an ongoing dialogue and planning with all of these forces so that we can come up with a strategy, tactics and strategy of how we can proceed to address the things that we prioritize as the glaring systemic inequities that we need to address.
The one thing I'd say is just follow up. It's like the one thing is, like, a lot of the data, at least from our point, like, I didn't know this before I started. Like, there's this thing called the MDAA. It's the Mass District Attorneys Association. It controls the data. Like, we don't even have control of our own data. Like, it's this Commonwealth-wide organization, right? Which is its own thing. So this isn't necessarily just a conversation about different organizations like the trial court or whoever sharing information with us. It's just like us having control even of our own stuff. And like resources, I know there was a question on the Q&A. I mean, it's the legislature. I mean, that's they're apportioning money to the different DA offices in their budget, right? That's how it happens. And it's not a joke. I mean, we were on furloughs last year for a fairly lengthy period of time because of COVID. And we weren't sure like how the budget was going to sort out. So people had to take like basically forced days off where you weren't getting paid. So it's a real issue sort of with that stuff. And I noticed there was something else in I think in the chat. I posted a couple of links. One is to the bureaus of the DA's office. If you scroll down and go to the Integrity Review Bureau, there actually are a couple of links in there. One of them is to an FAQ, like a frequently asked questions, that sort of explains, at least in sort of general terms, what we do. There's also a link to a case inquiry form in the description, but I think I also posted the regular one that goes directly to it. You can fill that out. You can send it in about a case that you're concerned about, or a person that is of your concern. But yeah, I mean, the community's priorities. I mean, this kind of goes to the rest of the issues. It's about sorting out what your priorities are and then voting. Like, I mean, that's really what it boils down to. And it's like some of this stuff, whether it's, do people want to have a conversation about, hey, life without parole? Maybe when they passed this law, whenever it was, that was okay with them because clemency was there and this other part of it. But that mechanism was working to whoever's satisfaction, right? Now clearly does not, and has not worked for a long time. It's like, all right, clemency is in the state constitution, can't really change that, or it's too difficult to change it, right? That system. But maybe that means we'd start talking about having a conversation about the other part of it. Does life without parole, does that stay? Or do we change that to something else? I don't know. But that's the kind of conversation we should have. Like, should it be, second degree murderers, you're eligible for parole at 15 years, right? Maybe first degree is at 20 or 25 years, and you try to catch the people that have rehabilitated or need not to be in prison anymore, right? I don't know. It's all about choices, right? Democracy, it's about choices. But people get, like I said earlier, about the money that's being spent on clemency, by clemency not occurring, right? It's costing us a fortune, right? As a society that could be much better spent doing something different with that money, right? So, but we've all made that choice. I didn't realize this until like the last 6 months or so, 6-8 months. That's the kind of thing. Sort of get the choices out there and let people vote.
Yeah, so we have about 10 minutes left until our 1 o'clock end time. I think there are really good questions coming in the chat. I have many more of my own, but I get to talk to David and Harold every week if I need to. So I'm gonna pivot to some of the questions that are in the chat, but I just want to make one comment about these kinds of bigger societal prioritization of funds questions that David just raised. And I happen to know that the deadline for filing bills for the legislature in Massachusetts is tomorrow at 5 p.m. And there will be a bill introduced this session, at least one, that is proposing to end the sentence of life without parole and to create parole eligibility for people who are serving life sentences. Those are important questions that are being raised in legislatures around the country. But that, I think, doesn't absolve prosecutors also of doing everything they can until that policy change becomes. And I want to also acknowledge that, the Suffolk County DA's office really is the only office in Massachusetts that has a unit like this that is trying to do this work and get people out of prison. But also there's a particular history of wrongful convictions that happened in Boston. And so in some ways, the Suffolk County DA's office has a particular responsibility to do this work. So there are all these kind of competing forces in how you think about the equities here. And as somebody who has worked on, who works directly with community-based organizations, I just want to lift up the idea that, if you argue for spending more money on DA's offices in order to be able to do conviction integrity work, that comes at the expense of funding other things that would produce safety and healing in the community as well. And so there are questions of resource prioritization within DA's offices that I think are just as salient as these bigger structural questions about what gets the bigger budget line item. And so with that, I'd like to move towards some of the questions that are flowing into the chat. Some of them are more technical questions that I think would be kind of short to address that I'm going to raise. So one is how to get a case looked at by the integrity unit, and basically whether things have to kind of go through a drawn out legal process, or there are kind of shortcuts that the DA's office can take to help people get released. David, do you want to take that briefly?
Yeah, like I said, I posted the link. The case inquiry form is there. There's information. I posted another link that you just got to scroll down to the Integrity Review Bureau. There's other information there that sort of explains how the review process works and how to apply for that. I don't know. I haven't found any. If anybody knows any shortcuts, please let me know, because I haven't found them. And that's part of the thing. It's like, people need to understand, like, a DA's, a prosecutor's discretion. Maybe this is wrong, but my impression of it is, like, early on, immense, like almost unreviewable amounts, like at the beginning of a case, like the charging, all that stuff, right? But the further the case goes along, and particularly post-conviction, it's not that absolute anymore. And the question, and actually it was a hearing I was in last fall, where, the judge was talking, and we were just sort of talking about the case, but sort of just talking. He was sort of musing, and he's like, well, I mean, post-conviction, like, who owns the conviction? Like, does the DA own the conviction? Does the court own the conviction? Like, who has sort of not the right, that's not the right word, but, that sort of the duty to oversee that, if it's one person or not, right? And I think, to a certain extent, I think that's an unanswered question about who actually has the authority to come back in and say, something. It's my responsibility to say this, that something's wrong here. I mean, I think there's an argument to be made that the ethics rules, 3.8I or whatever the paragraph is, I forget off the top of my head, I think you could tease that out to say that that's on the prosecutor to come in and say, I see this and there's something wrong. But like I said, it's an open question, like who has authority to do that?
Yeah. We're also getting a number of questions about parole in particular, and what role the office plays in opposing parole or supporting parole, and whether that falls under your purview, David, and also, obviously DAs have a tremendous amount of influence potentially, and also often have in other offices and in the past history of this office have always kind of just opposed parole in most cases, often tied to the purported interests of victims, surviving victims of the crime. And so if you could speak to that question and those bigger questions, and Harold, if you want to weigh in there too about, what role could prosecutors be playing in parole and to help kind of support people's release? I
mean, my answer can be very short. Parole is actually one thing I do not do. So I'm not involved in that.
So Harold, what do you think about those questions about parole and what role DAs could be playing in that, and whether that conceptually should fall under kind of conviction integrity and sentencing integrity, or if that's something that that separation makes sense?
Right. Well, typically, the prosecutors, many prosecutors, either have a role in parole hearings. They either can present an opposition to the parole, or they can present no opposition to the parole. And correct me if I'm wrong, I believe that DA Rollins' office has on occasion said that they did not oppose certain paroles, which was, I was shocked. When I heard that, I was like, wow, this is a new one on me. I was kind of shocked. But that's a very important piece there, because you have, often the parole hearing becomes a retrying of the case. And so if you have a situation where the prosecutor on the case, his office comes or her office comes in and says, well, we do not oppose this, that carries a decent amount of weight. What we need to brainstorm this issue to see if there's anything in the legislatively or that can be done to address that whole question that David raised about, who owns the conviction, and then the role, what the role that the prosecutor's office plays in a parole hearing, and and whether or not and what role in fact the community plays in those hearings, and what weight should the parole board be given to the community itself.
Absolutely. It sounds like there are other questions in the chat about a number of things related to parole. I just want to offer again, in terms of where legislation is, there are efforts again this session to introduce, and in fact, Cindy Cream has already introduced a bill 10 days ago to change the composition of the parole board, to change some of parole's practices, and to kind of create more opportunities for people to be released on parole, and to lessen the kind of surveillance and monitoring. And there are other bills that I know are going to also be introduced before 5 p.m. Friday tomorrow. So I think those questions are really salient right now. We only have a few minutes left. I think one question that I know comes up a lot in our community work is, when the office doesn't support a release, are there ways to do that still kind of move forward the opportunity for future releases, and what's the policy, or is there an office policy on when you feel that if you're unable to support the release, how to do that in a way that still creates the most opportunities for future liberty and for the development of the law in a way that recognizes in the existing kind of political economy of our law, right, of these limits on clemency and of the limits on parole, setting people up for opportunities to develop the law in a liberatory way. Harold and David, I'd love both of your thoughts on that as kind of a closing framework.
Well, I'll give you well, first, I think to really understand this, we have to understand the nature and practice of the parole board, not just the parole board, but what parole policy currently is in Massachusetts. And I'll use an example to go into that. It was the gentleman is now deceased. His name is Joe Labriola. And he was on a panel with me at Tufts, and his story was that he got medical parole, and somebody knocked on his door. It was the parole board, and what they asked him, they said, "Joe, why are you still alive? Why haven't you died yet?" They demands medical records, which he didn't have at the time, and he got, he was released. He got a little loving care, and he seemed to improve somewhat. And under the medical parole statute and regulation as it stands, he could have been sent back to prison. This man was in a wheelchair with oxygen. They put a GPS device on him, scared him to death. This man is a decorated war veteran. But this is what's going on with this board. What we have to look at is what can we collectively do as a community, as functionaries within organizations, as the district attorney's office. What can we do to address these types of policies? Because you have laws in place that are, not being relied on, not being enforced, and the practice of parole and clemency in Massachusetts is broken. It's totally, absolutely broken. We have a few glimpses now of some people maybe getting out, but there's hundreds, if not thousands of people who, have served enormous amounts of time and who've done all sorts of achievements, who are no threat to society, but for political reasons, economic reasons, they clemency is not available for them. So, I mean, that's how I would close out on the question. I was a part of a petitioning process for termination of sentence. I mean, they literally threatened me. They called me up and said that I was under investigation for a homicide. It was turned out to be totally bogus, but that was to threaten me, to get me to back off from trying to advance those petitions to get people out. But this is what's going on. So I sound the alarm, we really have to address this. If we're going to have a democracy, we have to begin to make it a democracy. We the people, government by the people. We are the last resort.
Thank you, Harold. And David, your closing thoughts?
the 10-second closing thought. There really is nothing to add to that. I mean, it's basically what I said before. It's understanding the sort of, there's this system that was set up, right, that doesn't work. It doesn't, I don't even think it works as it was intended to work. And I think there has to be a conversation about how do we fix this? And like, nobody wants innocent people in jail. Nobody wants people, if they're truly rehabilitated, they shouldn't be there because they can benefit the community, and they should be in the community, and we should be getting the benefit of that, right? How do we maximize, how do we make that happen, right? Because the system as currently constructed and functioning doesn't do that, right? So we all have to figure out the choices that we've got to make and vote accordingly and try to get those changes implemented.
Well, in closing myself, because I see that we're over 1 o'clock, I just want to thank our panelists, Harold and David, and also mention a closing note. I know the DA has done has really moved the office in a new direction with this and the creation of this unit. And also, when campaigning, met with members inside MCI Norfolk of the African American Coalition Committee, and spoke to a lot of men serving really long sentences about the process of potentially engaging in sentencing integrity work, not only conviction integrity. And I know that's something we didn't get to talk about as much on this panel, and a new direction that I know many people in the community who are joining us on this call feel not only that is an important avenue to explore going forward, but the DA may have a responsibility to act on given those meetings. So I leave that as a closing note for future directions we all hope to see from the office. And I know we'll all continue working and agitating, sometimes together and sometimes in tension, to try to advance, as Harold said, whatever we think of when we think of the word justice and whether it can possibly exist in the system as it's currently construed. So I leave you with those closing thoughts, and thank you everyone for being here today. Again, this was recorded and we will post it on our website, and also I will post links to the legislation that's been discussed today once it's live, and as well as share the bios of our two distinguished panelists. So thank you all so much, and I'll leave this open for people to interact in the chat a little bit longer, but this is the official closure of our event.
Great. Thank you very much for having me.
All right, thank you.
Thank you.